you believe in living a respectful life. You believe in self-help, which is the best help. The beautiful thought is given by the Dr. B.R. Ambedkar ji. Hello, my dear viewers. Hoping you all are doing great. I am Ms. Deepika Kanwar, Assistant Professor from Punjab. Today, we will discuss about a very important topic regarding the occupiers' liability to compensate members of public. My dear students, now I would like to start with the introductory part of today's lecture. The liability of tort can take on various forms depending on the circumstances surrounding the incident. The liability of tort is associated with monetary awards, but some forms of liability can lead to other remedies such as restraining order or an injunction. With this, the duty of a person in possession of land and building to take reasonable care about their safe condition arising in the following cases. Firstly, it may arise towards a person outside the premises. For example, a person using a highway or an occupier of adjoining property. Secondly, the duty of an occupier may arise towards the person entering the premises, while this duty to his neighbor or a person on a highway arises from the improper use of his property. His duty towards the person entering it arises from the conduct or behavior in inviting or permitting to enter it. Moreover, the duty, name of the owner or occupier of the adjoining property substantially form a part and has been considered under nuisance. Therefore, in some of these cases, negligence is a necessary or important element for liability. The Court of England had certain rules defining this duty towards the following categories of person. Number 1, invitees. Number 2, licensees. Number 3, trespassers. The above rules, however, includes many difficulties in their application to a new type of cases, which often lead to unjust results or failure of justice. In this regard, the rules of common law have been replaced in England by the statutory provisions. The Occupiers Liability Act 1957 provides a common duty of care towards visitors. With this, another statute, Occupiers Liability Act 1943, provided the protection against personal injury of persons other than occupiers' visitors. Now, in this lecture, I would like to discuss another important segment, that what is occupiers' liability? The occupiers' liability is concerned with the duty of occupiers to take care of ensuring the safety of persons within the premises. The Occupiers Liability Act 1957 and Occupiers Liability Act 1984 are the two acts which currently governs liability in this field. In both acts, an occupier owes a duty of care in respect to danger dues to the state of the premises or to things done or omitted to be done on them under section 1 Clause 1 of Occupiers Liability Act 1957 and Section 1, Clause 1, Subclause A of Occupiers Liability Act 1984. With this, the common duty of care, that of reasonableness, applies under Section 2, Clause 2, Occupiers Liability Act 1957 and Section 1, Clause 4, Occupiers Liability Act 1984. Nonetheless, the duty of care in Occupiers Liability Act 1984 only exists when the circumstances in Section 1, Clause 3 were there. Therefore, in determining a breach of duty, regard would be given to the degree of care and required the standards of care as employed in negligent claims. Now, with this, I would like to discuss something about the Occupiers Liability Act 1957. The Act of 1957 abolishes the common law category and provides that the lawful entrants are owed the same common duty of care. This duty is owed by the occupier to his visitors in the respect of dangers due to the state of the premises or to things done or omitted to be done on them according to Section 1, Clause 1, Subclause A. Before analyzing the central concept of occupier, visitor and common duty of care, several points should be made about the scope of the Act. Firstly, the provisions enacted which applies to regulate the obligation of a person occupying or having control over any fixed or movable structure, including any vessel, vehicle or aircraft under Section 1, Clause 3, Subclause A. Thus, while immovable landed property is clearly within this Act, therefore, two are movables such as ship and aircraft. Other less permanent structures such as diving boards, scaffolding and ladders. And in Australia, even a car has also been held to be premised. Secondly, the obligation of an occupier extend beyond the duty not to cause personal injury to a visitor and moreover to cover the damage to property suffered on the premises, whether the property be that of the visitor or of a person who is not himself a visitor under Section 1, Clause 3, Subclause B. Thirdly, with this, the liability may arise with respect to omissions. For example, owners of a public park who knew that golf balls were regularly hit there but did nothing to stop it were held liable to visitor to the park injured by a golf ball struck by a third party. Now, my dear students, I would like to discuss another important segment. Who is an occupier? Under Section 1, Clause 2 of this Act, provides that an occupier is a person who would have been treated as such at common law. Hence, the principle is to impose on an occupier of premises the same duty which are described as the common duty of care towards all his lawful visitors, except in so far as he is free to and does extend, restrict, modify or exclude his duty to any visitor or visitors by agreement or otherwise. The persons by whom and to whom the common duty of care is owned are the same as the persons who would at the common law be treated as an occupier and as his invitees or licensees. Important changes made by the Occupiers Liability Act. Now we are going to study this, another important segment. Firstly, the occupier owes the same duty to all his visitors, that is, persons who are lawfully on the premises, whether by his invitation or permission. The Act, therefore, does away with the difference between two categories of persons, invitees and licensees, and his duty towards them, whereas under the old law, there were three categories of persons: invitees, licensees, and trespassers, and a graduated scale of duties towards them. Under the new law, there are only two categories. Number one, visitors, and second is trespassers. Secondly, important change in that duty to visitors is formulated in terms very different from those of rules of the common law. It is described as the common duty of care and defined as the duty to take such care as in all circumstances of the case it is reasonable to see that the visitor is reasonably safe in using the premises for the purpose for which he is invited or permitted by the occupiers to be there. Thirdly, the Act proceeds to state some principles for guidance in considering the circumstances that may affect the degree of care required by the occupier. The first principle, circumstances, would include the degree of care and care for the visitor. The second principle, the Act deals with the effect of warning given by the occupier to visitor about a particular danger. The third principle, the Act deals with the responsibility of the occupier for a danger created by a fault of an independent contractor employed by him. Moreover, he will not be answerable for the harm caused to the visitor if the occupier has acted reasonably. Now, my dear students, I would like to discuss about visitors. Who is the lawful visitor? Visitor by invitation or given permission to enter the premises. The permission can be either implied or expressed. This permission is usually limited, for example, to some repairing jobs. By restricting the permission, the occupier can restrict the duty of care owed to the visitor. The occupier can change the permission to visit any time. However, it need to be shown very obviously to the visitor. My dear students, now in this lecture, I would like to discuss some common duty of occupier to visitors under Section 2, Clause 2 of this Act. The occupier needs to consider the characteristics of the visitor in question. For example, they must be prepared for children to be less careful than adult, and conversely, there is a lesser expectation when the visitor is a skilled worker. An occupier will not be liable for accidents caused by work conducted by independent contractors, provided that he has acted reasonably in using the contractor in question and has taken the proper reasonable step to check the competency and that the work was properly done. Where a visitor goes beyond the extent of the permission granted by the occupier, they are seen to be a trespasser. What amounted to such care, as in all circumstances of the case is reasonable, depended not only on the likelihood that someone might be injured and the seriousness of the injury which might occur, but also on the social value of the activity which gave rise to the risk and the cost of preventive measures. Now, I would like to discuss one case with you, students. Under the case Tollinson versus Congleton Borough Council, the defendant owned and managed a public park in which there was also a lake. The lake had sandy beaches and was a popular recreational venue where matching sub-aqua diving and other activities were permitted, but swimming was not. Notices regarding dangerous water, no swimming was posted. The claimant dived, striking his head on the sandy bottom. It was held that the defendant were not liable. Those people who took no notice of warnings could not create a duty to take other step to protect them. Now, after this I would like to discuss some important area of today's lecture, that is Occupiers Liability Act 1984, an act to amend the law of England and Wales as to the liability of persons as occupiers of premises for the injury suffered by persons other than their visitors, and to amend the Unfair Contract Terms Act 1977 as it applies to England and Wales in relation to persons obtaining access to premises for recreational or educational purposes. After this, I would like to discuss about trespassers. A trespasser is a person who enters the premises of another without his or her consent. However, if the occupier did not object the entry of other on the land, then it is assumed that he had consented for the same. Such visitors can get the right of the licensee. Now, there is one case which I would like to discuss with you. Lorry versus Walker. Facts. The defendant was owner of the land which was used by the public as a shortcut from and to the railway station. The defendant objected to this practice but had never taken effective action against the same. The plaintiff, while crossing the field, was injured by the horse which was owned by the defendant. The defendant contended that the plaintiff here was a trespasser and therefore he had no duty against him. It was held by the court that since the defendant had failed to take effective action against the trespassers for such a long time, therefore, the presence of the consent of the defendant can be assumed in such circumstances. It was observed that the plaintiff was a licensee in this case, and therefore the defendant was held liable for the injury. Duty of care towards trespassers. Contrary to possible expectation, occupiers still have a duty of care towards trespassers, which are set out in the Occupiers Liability Act 1984. The duty is at the less onerous level. It only comes into play if the occupier, number one, is aware of the danger or has reasonable ground to believe that it exists. Number second, knows or has reasonable grounds to believe that the trespasser is in the vicinity of the danger or may come into the vicinity thereof, and thirdly, may reasonably be expected to offer some protection to the trespasser. The duty of care itself is to take such care that is reasonable in all the circumstances of the case to see that the trespasser does not suffer any injury on the premises by reason of the danger concerned. This may be duly discharged by taking such steps as are reasonable to give warning of the danger concerned or to discourage person from incurring the risk. The occupier is not supposed to make his premises safe for the trespassers. However, he can't deliberately do an act to injure the trespasser. The occupier has the right to take reasonable steps to prevent trespassers from entering the premises, but he cannot do anything to harm them. For example, if the trespasser is injured by falling from the staircase, then the occupier will not be liable. But on the other hand, if the trespasser is injured because of the spring guns on the wall of which the owner has not given any notice, then the owner will be liable. The occupiers of the premises owes a duty of ordinary care. Now, coming to the next case, that is case Morton versus polluter. Fact: the defendant was cutting an elm tree near which the children were known to be present. The defendant did not warn the children, thus injuring a child standing nearby. When the action was brought against the defendant, he contended that the child was a trespasser on the premises. It was held that the defendant was liable because he had failed to give adequate warning to the child. Occupier's duty towards children. Children do not form a special class. They are treated as visitors or trespassers. But the age and intelligence of the errant is a relevant factor, and the court is to take this into consideration in deciding cases of a child visitor or trespasser. The Delhi High Court held trespassing children to be an exception to the general rule of honor, owing no duty of care to trespassers. In the case of Nitin Walia versus Union of India, a child visitor of Delhi Zoo aged 3 years put his hands inside the iron bar where a tigress was kept, and his hands were crushed by the tigress. It was held that the zoo authority should have put iron mesh on the road, which they did after the incident to prevent a child from putting his hand inside the rods, and were liable for damages, and the child was not guilty of any contributory negligence. My dear viewers, now we come to an end of this lecture. To conclude, the nature of the obligation of an occupier varies with the kind of visitors. If a person is a lawful visitor, then the occupier must take reasonable care towards the safety of the visitor and their property. Before the passing of Occupiers Bill Act 1957, lawful visitors were categorized into invitee and licensee, depending on the purpose of the visitor. However, now this distinction between an invitee and licensee has been done away with. It was also concluded that India follows the principle laid down in the cases of occupiers' liability if they follow the principle of equity, justice, and good conscience. So this is the crux and conclusion of today's lecture. I hope this lecture was helpful and informative to all of you. So thank you very much.